Okay, we'll go ahead and get started. Again, welcome everyone. Thank you so much for joining us tonight. My name is Michelle Clark Jenkins. I head the consulting group of Griffin and Strong PC. Also joining us tonight is Charlotte Christian, who's the Deputy Project Manager in charge of the Disparity study. So hold on, let me just share my screen. So the purpose of our meeting tonight is to introduce you to the Disparity study that we're conducting for Harford County, Maryland. And so the kind of a few housekeeping things. You are welcome to put questions in the chat room. Charlotte will be monitoring that chat room for us tonight. If you would hold your questions until I finish the presentation, and then at the end of the presentation, we'll be open for questions. If you can, please use your raise hand function like that one Miss Barbara had, 3401. That was her waving function. If you can use that or wave at us or something. So, and then at the end, if there's anybody who's on by phone, I'll invite them as well. So we'll get started. So first, to tell you a little bit about our firm, Griffin and Strong is a law and public policy consulting firm. We're a minority woman and woman-owned firm based in Atlanta, Georgia. Our firm specializes in disparity research. We do contract compliance, we do supplier diversity, we do training, we do program development, we draft legislation. We believe we have one of the most qualified teams in our industry. We have 4 attorneys, 2 PhD economists, a PhD in social psychology, and a PhD in anthropology. No study we've done has ever been challenged or overturned in court. As I go through this, you'll understand why that's important. Our CEO, Rodney Strong, was the Director of Contract Compliance for the City of Atlanta for 8 years. He was part of a group of attorneys who watched the Croson case. Again, I'll explain what that is coming up. The Croson case, as it came up through the courts, is the case that requires us now to have to do these disparity studies, and was part of the team that kind of crafted the idea of a disparity study in order to satisfy the requirements of the court. He was also the principal architect of the City of Atlanta's MWBE program that became the model for the country. Dr. Vince Egan is our principal researcher, and he's actually one of the few remaining expert witnesses in this field. He's conducted over 120, I think probably now it's over 150 studies, and has successfully defended 6 cases as an expert witness. So you are in good hands. So let me start off first with really the basics of what is a disparity study. I always like to do that because it kind of helps to manage your expectations about what it is and what it isn't. It's meant to be an objective research tool that determines whether a governmental agency is actively or passively discriminated against groups because of their race or gender. It's also been used to measure availability and the presence and the comparison and any gap analysis with non-race and gender groups like veterans or small businesses, but it was really crafted to deal with the issues related to the 14th Amendment. So when we use the term discrimination, it means the current effects of accumulation of discrimination, maybe current, maybe past. We're looking at what it is now, and knowing that that if it's based on race and gender, that it's the current effects of past discrimination. And we do that through a lot of statistical analysis as well as anecdotal or qualitative analysis. We also look at the current policies and procedures of the county. And when we finish this, we're really looking to see if there are recommendations we can make to the county about how they can be more inclusive in their procurement. So kind of why do we do disparity studies? So there was this case that I mentioned, City of Richmond versus J.A. Croson. That was a Supreme Court case that was decided in 1989. Before that, it had kind of been assumed that there was discrimination in the United States, societal discrimination, and therefore putting remedial programs based on race particularly was kind of an accepted practice in a number of municipalities and the federal government. You know, the federal government had to kind of let off with putting goals on its contracts, and then the municipalities and the counties around the country also adopted similar programs. Well, this case of City of Richmond, Virginia versus J.A. Croson came up before the courts. And for the first time, the Supreme Court said that you run afoul of the 14th Amendment, whether you are treating people based on race and gender, which are suspect classifications, based on malevolent discrimination or based on benevolent remediation. So in other words, in both cases, you're treating groups of people differently than other groups. You're giving preferential treatment. And so the Supreme Court said, the only way you can do that, and they said, first of all, we're going to look at this with strict scrutiny. And anybody who's an attorney will know that in law school, you learn that strict scrutiny means strict in theory, fatal in fact. What that means is whenever the court says strict scrutiny means it's a level you're not going to be able to overcome. Well, some of Rodney, along with some of the other people who were looking to address this issue, found a way to overcome it. And so what the court says in its decision is you must have a factual basis in evidence, that in essence, you've proved the existence of discrimination. And so the court also said, besides having a factual basis in evidence, which is really what a disparity study is, you also have to have any remediation has to be narrowly tailored to the findings of that factual predicate, so that it won't be over-inclusive or under-inclusive. So what that means is that even though we do a disparity study, we just can't recommend everything. We have to look at what did we find in the study, and every recommendation has to be rooted in a finding. It also said that before we go to race and gender conscious remedies, we have to fully have considered race and gender neutral alternatives. So we look at those first, and then if we feel like those won't resolve the issues for whatever reason, then we can go to race and gender conscious remedies. So Adaram Contract Constructors versus Pena was a case that came out later, which really then included women, and it also included the federal government's contracts, as well as applying to state and local government. HB Roe versus Tippett is the last case that was decided in your jurisdiction, for which our principal investigator, Dr. Egan, was the expert witness who successfully defended North Carolina Department of Transportation's case. You all are in the same circuit as judicial circuit as North Carolina, so that case was decided also. So these are the three cases that really dictate what we do. So everything we do, sometimes when I explain it to you, may sound a little counterintuitive, but it's all been crafted according to the case law that has happened since Croson. So what's happened since Croson is that Croson told us what we needed to do. It really didn't tell us how to do it. So over the years, people have continued to challenge these programs across the country. And so the courts make decisions, and we take information from those decisions to determine how to craft and recraft the methodologies. So this is really what a disparity study process looks like. It's why it takes at least a year to complete. These are all the pieces of it, or the major tasks. We do a legal analysis. We do a deep dive into policies and procedures, a lot of collecting and cleaning data. I'll talk about relevant market analysis. I'll go a little bit more in depth about what these analyses mean. We also do a utilization and threshold analysis, availability analysis, the all-important disparity analysis. We look at private sector. We collect anecdotal evidence, some of which we'll do tonight. And then the final report with our recommendations. So the first thing is policies and procedures. So We've already begun those. We look at first all the written policies that the county has. We interview their staff who's involved in procurement. And what we're trying to find is the answer to three things. One, do any of the policies and procedures present a barrier to MWBE inclusion just on their face? Secondly, do procurement personnel understand the policies and procedures as it relates to, as written, as it relates to MWBEs, or as MWBEs, minority and women-owned firms, can be affected? And then the third is, do the procurement practices match Harford County's policies and procedures? And then, of course, all of that is to find out what policies and procedures could be modified to better promote MWBE inclusion. And then the markets that we're studying. So the first thing we have to say is, what are the parameters of our study? One of the parameters is geographic. So are we looking at every firm in the country? Where are our geographic parameters? So that's really determined by the existing spend of the county. So what we do is we look at where the county has spent at least 75% of its dollars over the study period, which is the last 5 years. So where have they spent their dollars, in what geographic location? Where are those firms located? Is it going to be just in Harford County? That's very unlikely. But then we'll go out to the MSA, we'll go out to the CSA, we'll look at whether it crosses state boundaries, but where, kind of making a radius around Harford County and pulling out, where is that point in which they've already been spending at least 75% of their dollars? That becomes our geographic relevant market. And then we're only looking at firms and only analyzing firms within that area. So if let's say it's the CSA, then we'd not be looking at any firms that are in California. The other is product market. So we want to make sure we're only including in our analysis firms who do the kind of, who provide goods and services that the county is purchasing. So then the easiest part of this is utilization, like where are they spending their money? And we do look at payment records, because award records are not as reliable as payment records. So we look at every payment in procurement that the county has spent during the study period. And we're looking at just both prime utilization and we're looking at subcontractor. Now, the county doesn't track subcontractor data currently. And so we'll be doing a prime vendor questionnaire that'll go out to all the primes to ask them who their subs were and how much they paid them. So, of course, we won't get back 100%, so that'll become a sample analysis. We disaggregate all of our analysis by ethnic group, so it'll be by African American, Asian American, Hispanic American, Native American, non-minority, woman, and then the non-study group, which is non-MWBEs. Non-MWBEs could be Caucasian male-owned firms, it could be publicly held corporations, or it could be non-certified firms, because we're only looking at certified firms in our counts. We also do a threshold analysis. A threshold analysis looks at what level of contracting is the county doing. That helps us on two levels. One is we find that there seems to be a misunderstanding that small firms cannot be prime contractors. And why is that? Because people say, well, you can't do a $2 million contract. Well, that may be true. Maybe you're too small to do a $2 million contract, but is the county only doing $2 million contracts, or is the county doing a lot of $50,000 or $70,000 or $100,000 contracts? So it hurts us to see the level of contracting and the capacity of firms who can potentially perform as primes. So then we look at who are the available firms in the marketplace, and we use a methodology. There are a couple of methodologies to do this. We use the list approach, which means we look at all of the counties, bidders, vendors, awardees, payees. We look at certified firms. We look at third-party lists like the Maryland DOT list, and we put them all together and kind of create this big master vendor file. And from that, we calculate the percentages of firms who are in the relevant markets and call that availability. So the firms need to be doing business within the relevant market in the areas where the county is doing business, and they also have to be at least registered to do business with government. So then the disparity analysis, which is kind of the central to this whole study. So a disparity analysis really just compares availability utilization. So if I have 100 engineering firms in your geographic relevant market, and 10 of them are owned by African Americans, I have a 10% availability of engineering firms. But then when I look at the spend that the county's doing, let's say I only see 2% spend with African American owned firms in engineering. So I have a 2% utilization compared to a 10% availability. That's a disparity. We then have to determine whether that disparity is statistically significant. If I'm looking at 2% compared to 10%, that's statistically significant. Maybe 9% to 10% may not be. We also disaggregate all of this utilization by year. So you'll see in the study, not just a total over the study period, but you'll see their utilization by year. So then at the end of that, we also not have to just determine whether it's statistically significant. We also want to determine what was the likely cause of that disparity. So we do a regression analysis, which says there are a number of other likely causes, like the size of firms, how long they've been in business, how many employees they have, what their revenues are, that could explain why there's a disparity. So we kind of equalize for all of those other possible explanations for why there's a disparity. And after we kind of factor them out, if there's still a disparity, then we can actually make a legal reference to there being a level of discrimination. So we don't just stop at that analysis, because if this had been a certain time in history, it would have said, okay, there are 0 Hispanic American owned construction firms that we used. There are 0 in the marketplace, no discrimination. Well, we have to look a little further about that. We want to look at, is there discrimination in the marketplace? Because discrimination in the marketplace can affect the likelihood of self-employment. It can also affect the likelihood of credit market discrimination. So we look at those kind of factors and see if the race and gender status of firm owners affects their ability to get contracting in the marketplace. So then one of our last analysis is anecdotal. That's where you all come in. It's a critical part, because at the end of all the statistical and the numbers and the tables and all those things that you see in the regression analysis, and if it all boils down to there are disparities, it doesn't tell us how to fix them. However, when we look at the policy, we can look at policy, and because of our expertise in this area, we can look at policies and make some determinations. But a lot of the information on how we remediate comes from the public and from the business community, because you begin to tell us about your experiences doing business, attempting to do business. And if you haven't done business with the county, why not? So we're asking those questions in a lot of different ways, but that's basically in all of the anecdotal what our questions are. So that'll be tonight. Some of you will tell us, have questions, you may have comments. At anecdotal interviews, we do one-on-one interviews. Those are randomly selected. So if you're asked to participate in one of those, please do. We do a broad survey of business owners. So check your emails probably sometime late summer. You'll see a survey of business owners come out from us where we're trying to get information. It's kind of a baseline information about what's happening with firms in your marketplace. Towards the end of the study, we'll be doing public hearings and focus groups. We really do want to connect with business, civic, and trade organizations. We want to meet with them, but also we need those organizations to help us connect with firms. We have lists of governmental firms who are included in our availability, but we also want firms because we want to know what it helps for firms to grow. What is it going to take if you're a business out there and you would like to be doing business with government? Why haven't you been? So we need to know that information. We're really not doing a needs assessment, but there's a little bit of this that winds up being a needs assessment because you start to tell us like, are you certified? No, I'm not certified. Well, why aren't you certified? And you'll tell us all the reasons why you may not be certified. We'll ask you if you're registered to do business with the county. Well, I'm not. Well, why aren't you? And you'll tell us all those reasons. We also would like email and social media comments because there's some people who just don't want to, tell their story verbally. So you're welcome to tell your story to us in emails. So at the end of the study, we'll present our findings and recommendations. Again, our recommendations will be based on best practices and innovative approaches. They will be unique to the findings of your particular study. So you all can get involved. That if you are contacted to participate in an interview or asked to fill out the survey of business owners or asked to participate in a focus group, please say yes. And also please attend the public hearings when you have an opportunity to. You can email comments to us. We have a dedicated email address, harfordstudy@gspclaw.com. And Charlotte will put that in the chat room for you to see. We also have a dedicated website, which is up. Yes, Charlotte, it's up. And so it's where you can come for information if you want to find out when our public hearings are, once we've scheduled them, or you want to make comments, or you just want to see more about our firm or about what the study is, you can visit the website at harforddisparitystudy.com. We're also pretty active on social media, and you can see in our tweets and in our LinkedIn or Facebook, the other projects we're working on around the country. So our timeline looks like this. We really started this in, really at the end of the year, just before Christmas. So we're doing like data assessment, legal review, policy review, then we move on to data collection. That really is the biggest part. Collecting this data for the whole study period is a big task, and cleaning the data and then analyzing it really starts now and goes all the way through the study. We launched our website, informational meeting. We'll go on to the survey and the anecdotal interviews and preparing databases. And then around Christmas time next year, this year, we'll be presenting the results of the study. So that's our presentation. You can find us at gspclaw.com. So now we are open for any questions you might have.